good article. Take a picture of him. There we go.
All rise, come to order. The 4:33 District Court is now in session. Honorable Dib Waldrip presiding.
Everybody can be seated. Okay, this is cause number C 2013-1082B. We're here today and convening a temporary injunction hearing, and I'm going to begin by having just some opening statements and or presentations, and then take a little bit of evidence today. The media is welcome during this opening phase and period of the trial, but so as to preserve the integrity of the process. As far as any witnesses and testimony, at a certain point when we get down the road here, I'm going to ask that all recording devices be removed from the courtroom and the third floor when we begin the testimony. But at the outset, you're certainly welcome. I want to give everybody a fair opportunity and just balance all the interests concerned. But at this time, Mr. Jeffrey, just by way of opening.
Excuse me, Your Honor, may I speak briefly? George Spencer, one of the counsel for defendant Church of Scientology International. Your Honor, I understand you have set the hearing on our motion to disqualify for 9 a.m. tomorrow. Is that
Yes.
Your Honor, we respectfully object to this proceeding going forward before that motion to disqualify has been determined, and object to this temporary injunction being until the motion to disqualify is heard and determined.
Again, trying to balance a lot of different issues. I respectfully that's denied or overruled. Yes, sir.
I'm ready to proceed, Your Honor.
You may.
Okay. Your Honor, my name is Ray Jeffrey, and Elliot Capuccio and Mark Wiegand and I represent this lady who's sitting right here. Her name is Monique Rathbun. She's sitting next to her husband, Mark Rathbun, who's also known as Marty Rathbun. This case is about the intentional, premeditated harassment carried out by the defendants against the plaintiff, Monique Rathbun. The lawsuit is just beginning, but the court, as you know, is already having to confront a couple of issues. Normally, the court doesn't have to get too involved until we get a little bit farther down the road. But there are a couple of issues that the court will be facing. One, should the temporary restraining order that is protecting Mrs. Rathbun, should that be extended into a temporary injunction? And two, are these defendants subject to jurisdiction here in Texas? We believe the unequivocal answer to both of these questions is yes. Mrs. Rathbun deserves continued injunctive protection against these defendants, and the defendants should be made to answer these charges here in Texas. The relevant evidence in the case will be serious, both as to the ordeal suffered by Mrs. Rathbun, as well as the culpability of the defendants. Here's what the evidence will establish. For more than 3 years, the defendants have shattered the privacy and the tranquility of Mrs. Rathbun's life. She has endured a complete loss of privacy, nonstop surveillance, videoing, photographing, face-to-face actual confrontations, intimidation, insults, harassment of her family, her friends, her co-workers, humiliating, nasty pranks, if you want to call them that. I think they're actually worse, but I can't think of another word. And finally, an interference with hers and her husband's ability to make a living. All of this has gone on for more than 3 years. Well, at the end of last year, Mrs. Rathbun really reached the breaking point. The defendants had made her life unbearable at her own home down in the Texas coast. Before the harassment started, she and her husband had lived a happy waterfront lifestyle down in Ingleside on the Bay, near Corpus Christi. They had to give that up. At the end of last year, they moved up here to Comal County to a house in the Rimrock Ranch subdivision over just off of 1863 in Bulverde. The house seemed ideal. It was set back off of the road on some acreage. It was hidden by trees. They had good, solid neighbors on each side. In fact, the neighbor on one side is the landlord leasing them the house that they have leased. Behind them is dense, unoccupied. So they missed Ingleside on the Bay, but they appreciated what they had found up here in Comal County. They breathed a sigh of relief. They enjoyed the tranquility here. They were still followed sometimes. There were still private eyes or other agents of the defendants that they could see lurking around. But at least they felt secure in the privacy of their new home. That was until very recently when a stranger, a suspicious stranger, showed up on the property behind them. That was the defendant, Steve Sloat. He was calling himself Greg Sloat. He's a former deputy U.S. Marshal. And he gave a story about leasing the property behind their house to put an RV on. The details of the story really kind of stunk to high heaven. The Rathbuns, after what they've been through for over 3 years, were pretty suspicious. Then, just maybe a month or so ago, they discovered on this wooded property behind them a high-tech, camouflaged, human surveillance camera. The camera was pointed directly at their home and at the driveway. They have a long caliche drive, you'll see, coming into their home. So not only would they be surveilled, but people who came to see them would be surveilled. The camera, as I said, is high-tech, set up to transmit images over the cellular system. It's a camera designed for law enforcement use, not something used by deer hunters or people interested in game management. When that happened, Your Honor, Mrs. Rathbun was absolutely distraught. It finally came crashing down on her. They could run, but they couldn't hide. So we're here today because as fearful as Mrs. Rathbun is of these defendants, she realizes that her only choice, the only option, is to stand and fight. That's why we sought the TRO, and that's why we're seeking a continuation of the injunctive protection into a temporary injunction. And I'll remind the court, we've got all these defendants and their forces here. All the court has ordered them to do is not harass her and follow her and surveil her. That's why we're here. So we brought a suit for injunctive relief to make this abuse stop, for actual damages to compensate her, and for punitive damages to deter them from doing this conduct in the future, and to set an example that this kind of behavior will not be tolerated here in Comal County, Texas. One point I would like to make to the court is this is not a religious case, even though it involves these corporations that are all part and parcel of this Church of Scientology, and you'll get to learn a little bit about that in the case. But it's not a religious case. Mrs. Rathbun has never, ever been a member of the Church of Scientology. We're not here about their theology or their beliefs. They can believe whatever they want to believe. That the court is not going to be called on to make any determinations about any of that kind of stuff. This case is about a powerful organization and its duty to behave lawfully in a civil society. It's also about the rights of a law-abiding Texas citizen to live in peace. I would be surprised if any of these lawyers got up and quibbled about that people have a right to be left in peace and that a corporation has an obligation to behave lawfully in a civil society. I don't anticipate that's what the battleground will be. I do expect them to fight like crazy to deny involvement in all of this bad behavior. I think that will be the battleground of this case. Who is behind this organized campaign of harassment of this nice lady? We will prove that one person is behind it. A man named David Miscavige, who is the self-proclaimed Pope of Scientology. Mr. Miscavige used, the evidence will show, the other defendants as co-conspirators to carry out his plan. I need to summarize what the evidence will be in this regard. What will be proved? To untangle any legal dispute that relates to these defendant corporations can be bewildering, and I urge the court not to underestimate this. The evidence will show that corporate Scientology's confusing complexity is not accidental. It is deliberate, and they have spent vast amounts of time and treasure to construct it. They have designed the corporate structure and all of these legal formalities for one purpose: to shield Scientology and Scientologists from criminal and civil liability. Scientology's founder, L. Ron Hubbard, not speaking about the faith or anything like that, but speaking about the practicalities of the corporations, described their corporate legal structure quite proudly as quicksand. He also said, and I'll quote, "Every time they shoot at you on the right side of the horse, you're on the left side. And then they prove conclusively you're on the left side of the horse, and you prove conclusively that you're on the right side of the horse." They go mad after a while. This is what the basic legal structure is. Corporate Scientology is a wealthy enterprise with billions of dollars to protect. After a 30-year battle with corporate Scientology, even the IRS gave in and granted tax-exempt status as a church. Before that, the government's position was Scientology is a business. And regardless of one's feelings about whether or not corporate Scientology should be regarded or recognized as a church, and that's debated a lot today, it's safe to say that its non-religious side is unlike that of any church that any of us would be familiar with. It has a disciplined group on the corporate side of agents who are responsible for scorched earth litigation and dirty tricks operations. This group is called the Office of Special Affairs, or OSA. It spends millions of dollars annually with the goal of destroying or neutralizing perceived enemies, such as Ms. Rathbun.
Your Honor, could we approach?
Yes, sir.
May I proceed, Your Honor?
Yes, sir.
There's one piece of historical evidence that is well documented in numerous books, histories of the church, etc., and that is absolutely critical to understanding the defendant's tangled web of corporate structures. And that is the fact that when the Office of Special Affairs was called the Guardian's Office, you'll hear about that in this case, it committed the single largest secret infiltration of the United States government in American history. Fortunately for American citizens and taxpayers, they were caught by the FBI. This was called Operation Snow White. Nearly a dozen Scientology agents went to federal prison. This is not any kind of a secret thing I'm letting the court in on. This is well documented. In fact, one of the Scientologists who went to federal prison was Mary Sue Hubbard, the wife of Scientology's founder. Scientology's founder, L. Ron Hubbard, narrowly avoided.
Your Honor, I'll object. What's the relevance of this?
I'm about to explain, Your Honor.
Injunction, with regard to alleged acts against Ms.
Yep.
Rathbun. Why are we going into things that are back in the 70s?
May I respond?
Well,
Your Honor.
And I appreciate that. This is opening statement. So
Yes, Your Honor.
Try to keep it to the
I
way.
simply recited some facts. There might be They might be surprising or startling facts to people who are unfamiliar, but I've literally just repeated the facts that are out there in the world, which is that the Guardian's office was caught.
One at a time, please.
I think the real issue here is just, this is an opening statement.
Yes, sir.
Jeffrey, if we can just kind of get to the, I'm understanding there's, there's web, and that the web is extensive.
Okay.
Both extent and history.
I'll move on.
Thank you.
Thank you, Your Honor.
Judge, he's playing to the media. It's irrelevant to any of the injunctive elements
It is.
before this court, and he's doing it purposefully. He's attempting to get in confidential information. Now he's getting.
I understand. I mean, he is zealously representing his client, as I trust you will as well. And I know that we're not in front of a jury, and
We are in front of the media, Judge, and that's the reason we're here. And he's doing it purposefully. It's not relevant. It is an opening statement, but it's supposed to be what the evidence will show. And when we get to the point where it's evidence, what we show, there's going to be a relevance objection, and it's not relevant.
Your Honor, I'm trying to tell the court what is the relevance, and he keeps jumping up and objecting.
well, I think it will probably help if we can, as best possible, avoid the argumentative type language in our opening statement. So,
Okay. Yes, Your Honor.
trying to give everybody their due. So.
Okay. The evidence will show, Your Honor, that after the Guardian's office affair, a major project occurred in corporate Scientology, which was, how do we keep doing the same activities that we did before, but protecting ourselves from further liabilities? And that's how you come up to today.
Judge,
They,
the only way he could know that is if he has attorney-client communication.
Your Honor, there are
only
numerous
way
books
he
you
could
can
know
read this
that.
in. It's out there.
Okay.
This is, Your Honor, this is well documented in the media, in history books.
It's our concern about the privilege issue, it's concern about the disqualification issue. We cannot address this without the motion to disqualify being heard. And you asked him to not go into confidential.
Well, I haven't
There
heard
is
it yet.
none.
I mean, I haven't heard anything more than generalities at the moment. So, at the moment, I'm over
I'm trying to move on, Your Honor. What the evidence will show in the case is that from the days of the old Guardian's office, they created a new structure called the Office of Special Affairs. Nothing secret about this, nothing I've learned of attorney-client privilege about this. The purpose of this change in the corporate structure was to shield from liabilities. And the court, this is directly germane to what the court is going to have to do in this case. Is this an effective shield or is it not? Is it a sham? In the testimony, we'll give details about all of this, Your Honor. Out of deference to the court, I'm skipping over a few things here. So let's get down to the issue that I talked about at the beginning, which is, what will the battleground in this case be? I have not heard Mr. Schreiber, when he stood up, say that they're going to admit, the Church of Scientology International and the Religious Technology Center and David Miscavige, that yes, we did all this stuff to Mrs. Rathbun. They're not going to admit that. That is going to be our burden to prove that. The evidence will be that Mr. Miscavige, in spite of this elaborate corporate structure set up, he rules and runs all phases of the Scientology corporations with absolute authority. They take the position, and you'll hear about it, that he is merely the chairman of the board of the Religious Technology Center, which is not supposedly an operational wing of the various Scientology corporations. Supposedly, the Religious Technology Center is completely uninvolved in the management of the different Scientology entities. The evidence will be that in spite of this seemingly hands-off position of chairman of the board of this one entity, Mr. Miscavige runs anything and everything that he cares to run within the various corporations. And there is a key for your honor to understand how this works. And that is, there is a unifying organization that runs through all of the Scientology corporations. It is called the C organization. It's called the C, and that's S-E-A, not like a C corp that lawyers think of. C as in ocean. The C organization runs through all of these corporate entities. And it's called that because it was created by Scientology's founder, L. Ron Hubbard, while he was running Scientology from a fleet of ships in the Mediterranean. Also, Mr. Hubbard had a background in the Navy. So it's the Sea organization, as in the ocean. You'll also hear it referred to for short as the Sea Org. That's how they commonly refer to it. They tend to abbreviate organization into org. The evidence will be that the Sea organization operates with a military discipline and command structure. Members who serve in the Sea Org sign contracts to serve for 1 billion with a B, 1 billion years. Every significant corporation in this network of Scientology, the managers and the executives and the directors are all members of this quasi-military organization called the Sea Org.
If I can interrupt, I mean, just for the purposes of maintaining the status quo of the PR, I mean, if we can.
Yes, sir. I'm concluding.
Thank you.
Because if the court will recall, our basic premise is that there's really one man who has been behind this harassment of Mrs. Miscavige. And that is because David Miscavige is Captain Miscavige. He is the commanding officer of the Sea Org, which actually runs every one of these corporations. He is the commander-in-chief, as L. Ron Hubbard, the founder, was before him. There have only been 2 commanders-in-chief in the history of this organization. His title is literally Captain Miscavige, and that is as in captain of the ship. We will show detailed evidence of how Captain Miscavige actually runs things, and that he in fact micromanages everything, and in particular, relevant to this case, he micromanages matters relating to perceived enemies of the church. We will show in evidence that in Captain Miscavige's eyes, there is no bigger enemy than Mrs. Rathbun's husband, Mark Rathbun. Mr. Rathbun was the second in command to Captain Miscavige until he fled Scientology's desert compound back in 2004. He came to Texas from Scientology and fled Scientology. He moved as far as he could from basically the 2 headquarters of the church in Clearwater, Florida, and in Los Angeles, California. After his service in Scientology, he met Monique Rathbun, the plaintiff in this case. They got married. They started a quiet life down on the Texas coast together. But at some point in their history, specifically 2009, he spoke out about abuses that he had seen in the church. And it was at that point that this harassment began that I referred to in the beginning of my opening statement. We will show, and I'm in conclusion, Your Honor, we will show that there is literally no one in any of Scientology's corporate structure that would have the authority or the courage to order an operation such as this operation that has gone on for the last 3 to 4 years, except for Captain Miscavige. The evidence will establish that Captain Miscavige ordered and supervised this operation against the Rathbuns. And finally, this operation violated Mrs. Rathbun's legal rights. Texas law provides her remedies for that. And under Texas law, Captain Miscavige and his co-conspirators should be enjoined from inflicting further harm on Mrs. Rathbun, and he and anyone else involved in this unlawful operation should be made to answer these charges not in Clearwater, Florida, or Los Angeles, California, but Comal County, Texas. Thank you, Your Honor. We can provide her with cards if that's it. It's Elliot Capuccio right here and Mark Wiegand. Not the easiest names to spell, so I'll give you the cards.
Inside the room to the extent they intend to challenge the jurisdiction of the court over individuals or entities, not waiving anything by proceeding in this fashion.
Thank you.
Yes, sir.
Judge Les Strieber with Davis Cedillo in Mendoza, in San Antonio. And my firm is representing Church of Scientology International, for the court reporter we'll be calling it CSI a lot. And so that's who I represent.
May it please the court, George Spencer of the San Antonio law firm of Clemens and Spencer, co-counsel Mr. Strieber and his firm, were defendant Church of Scientology International.
And Your Honor, I'm Jonathan Hull. I represent Stephen Gregory Slovis.
Good morning, Your Honor. If I'm successful in having my pro hac vice application approved by the court, my name is Bert Dykesler of Kendall, Brill, and Krieger, and I'll be joining as co-counsel to CSI.
Mr. Jeffrey, Monkey Drake, and sir.
Yes, Your Honor. We obtained an order for substituted service, and but he has not appeared.
Okay.
And technically, his answer isn't due yet, but he's not appearing to contest thus far the injunction.
With all that being said, then who wishes to go first?
If I could begin, Your Honor.
Yes.
Lamont Jefferson again for specially appearing defendants, Religious Technology Corporation, who I'll refer to as RTC at some points during my remarks, and Mr. David Miscavige, who is the ecclesiastical leader of the Church of Scientology. And Your Honor, I appreciate this opportunity. When you began, you said you'd like to hear opening statements and about the issues that are involved in the temporary injunction. And so we were expecting to hear something about why this situation involved irreparable harm, an imminent risk of loss, inadequate remedy at law, those sorts of things, the sorts of things that we argue all the time in temporary injunction hearings. Instead, we heard none of that. We heard a diatribe from Mr. Jeffrey about the history that dates back many years of the Church of Scientology. And just for the record, and this is undisputed, Mr. Rathbun has not been inside the Church of Scientology with any authority since before 2004. So he's been gone from the church from 2004 on. And the evidence that Mr. Jeffrey says he will present to you is evidence from a decade ago. And that will be the evidence that he's going to rely on to try to establish a connection between what's happened in Texas and between my clients, David Miscavige, and the Religious Technology Center, or RTC, of the Church of Scientology. So, Your Honor, my remarks are directed at our special appearance, and please consider this an opening statement for that purpose. I'll try to be brief, I'll try to be direct. But what the court, with respect to the special appearance, what the court will have to decide is whether or not Mrs. Rathbun, Monique Rathbun, can present the court with credible evidence today about what's going on today within the Church of Scientology. What the plaintiff attempts to do in order to show that connection is proffer affidavit and live testimony at trial from Mr. Rathbun based on his knowledge in 2004 and before, when he was at the church. Well, we have what Mr. Rathbun said when he was in a position of authority with the church with respect to whether Mr. Miscavige and the RTC had participated in any illegal, unlawful, improper way. And what Mr. Rathbun said when he was still with the Church of Scientology was this: as chairman of RTC's board of directors, Mr. Miscavige's corporate authority is narrowly circumscribed. His corporate authority does not, and that's emphasized in the text, embrace any, emphasized in the text, participation in the corporate affairs of CSI, CSC, or any other Scientology church or related entity. This fact was confirmed by the Internal Revenue Service after the most exhaustive examination of tax-exempt organizations ever undertaken by that agency. I was there. I participated in the entire administrative proceeding before the IRS on behalf of the RTC. Moreover, I began my employment with RTC on the same day in March of 1987 that Mr. Miscavige began his employment with RTC. And I can state that neither Mr. Miscavige's duties nor his authority has changed since that day. There is nothing secretive, hidden, or untoward about what RTC is or does. RTC's function is to ensure the orthodoxy of the practice of the Scientology religion. Its ecclesiastical relationship with other Scientology churches is as a result of arm's length licensing agreements by which churches so authorized by RTC use the intellectual property marks of the religion owned by RTC. Those licensing agreements were reviewed by the IRS as part of its examination leading to tax exemption, and the IRS was satisfied that they did not infringe upon the corporate autonomy or independence of the individual churches within the hierarchy. One last brief excerpt. Again, these are the words of Mr. Rathbun, Mrs. Rathbun's husband, on whom they're relying to show this web, as they describe it. Mr. Miscavige's role within RTC is that of chairman of its board of directors, the corporation's most senior position. By virtue of that position within the entity responsible for the orthodox practice of the faith, he is the senior ecclesiastical authority in the religion on all matters of Scripture. That is all, period. Those are the words of Mr. Rathbun when he was with the church and before he brought this lawsuit. Your Honor, I am not a Scientologist, but I am a disciple of the First Amendment. And that's what is really at issue in this case. What Mr. Jeffrey wants as a result of this hearing is the opportunity to take the deposition of Mr. Miscavige, who is the ecclesiastical leader of a worldwide church. That's what he was aiming for. One of the things that was on the schedule for today was their motion to get additional discovery so that they could argue the special appearance hearing, including their request to take the deposition of Mr. Miscavige. That as soon as they discovered who was on the other side of this case, the lawyers on the other side of this case, Mr. Jeffrey issued a deposition notice, not for the investigators who supposedly harassed Ms. Rathbun, not for even the OSA, who they say is behind all of this, not for anybody who was involved in Texas activities, but for Mr. Miscavige. They wanted to take the deposition of Mr. Miscavige. And they'll ask for that order again in this case. They'll ask you, Your Honor, to order that Mr. Miscavige submit to them for a deposition. And I'll concede that such an order would apply a maximum amount of pressure on the church. And it would give the plaintiff a maximum settlement leverage position. But it would also be run afoul of the First Amendment of the Constitution, and it would be a gross violation of the constitutional guarantee of freedom of religion. Ms. Rathbun is perfectly capable of proceeding with all of her complaints in this lawsuit against the party that has appeared generally in this case, the Church of Scientology International. They have sufficient assets to address any damages that she claims she's suffered as a result of this supposed investigation. Your Honor, Texas law recognizes the ecclesiastical abstention doctrine, which I believe clearly applies here with respect to their request to take depositions, discovery, harass the leader of an international church. In Williams versus Gleason, a case that the court may be familiar with, the court said very specifically the Constitution forbids the government from interfering with the right of hierarchical religious bodies to establish their own internal rules and regulations and to create tribunals for adjudicating disputes over religious matters. What Mr. Jeffrey wants to do by this discovery that he's seeking is go behind and test whether the way the church governs its activities is lawful. That's their single business enterprise vague allegation that they make in this case. The law doesn't allow that, Your Honor. The law says civil courts may not intrude into the church's governance of religious or ecclesiastical matters such as theological controversy, church discipline, ecclesiastical government, or the conformity of members to standards of morality. This is an overview of the Church of Scientology. Just a couple of pictures. I'm not going to take very long. These people are all faithful Scientologists, the people that we see depicted in these scenes. Mr. Miscavige is the ecclesiastical leader of the Scientology religion. We don't have to agree with the religion. We don't have to debate about the religion. All we have to know is that the IRS has recognized it as a religion. The United States recognizes it as a religion. The members of the church are faithful adherents to this religion, and that must be respected. Mr. Miscavige presides over meetings like this, internationally, that include members of the church from many different persuasions, from many different languages, from many different churches. So it is crystal clear, Your Honor, what's going on here. This is a simple case of an invasion of privacy by a woman who feels like she was abused. Okay, I get that. I get that. If someone has done her harm, she's entitled to recompense. She's entitled to make her case. She's entitled to demonstrate and get recovery from those who violated her rights if they did. That's not Mr. Miscavige. He's not the one who's behind this, and they've got the person who is behind this. They sued an entity that they say is responsible directly for all of the conduct that she supposedly suffered. Let them prove that that entity is responsible. If they're successful in their proof, that entity will have to answer for all of its activities, not Mr. Miscavige, and not the RTC, the Religious Technology Center. Just on so we have a special appearance that is pending. I want to just outline for the court how the court ought to analyze and decide whether this special appearance is good. The result of the special appearance, if we're successful, would be the dismissal of Mr. Miscavige, the dismissal of the RTC from this lawsuit because they don't have sufficient contacts with this state. We have affidavit testimony. We'll offer testimony from the stand that they have no sufficient contacts with the state so that this court could exercise jurisdiction over them, so they should be dismissed. That will not mean Ms. Rathbun doesn't have a remedy. She'll have a remedy. But that's not why the reason why the plaintiffs sued these individuals is because they believe, they understand that this is something that the church cares violently about, cares mightily about, that is preserving its ecclesiastical independence, preserving its ability to govern itself. So they filed their original petition. Original petition stated no jurisdictional facts. They simply named Mr. Miscavige as a defendant. They named the RTC as a defendant, and they cited this private investigation activity, and that was it. They didn't even suggest how these activities were tied together. We filed our special appearance. At that point, they filed their amended petition, and in their amended petition, they claim a bunch of things that have nothing to do with whether Mr. Miscavige and the RTC has a connection to the activities in Texas. Again, the only facts that they can rely on are facts that happened 2004 and before. So they're not bringing forth any evidence, any direct evidence, that anything that's happening to Ms. Rathbun has anything to do with Mr. Miscavige. And in fact, it does not. Mr. Miscavige is busy on other things. He doesn't know Marty Rathbun. He doesn't care about Marty Rathbun. He's opening churches around the world for the faithful who are part of the Church of Scientology. They allege now that somehow Mr. Miscavige must be the one who said, go and surveil Ms. Rathbun. That Mr. Miscavige himself said, go and surveil Ms. Rathbun to, I presume, to the private investigators who did it. Even if that were true, which it is not, even if that were true, the case law is absolutely clear that that would be insufficient to support jurisdiction against Mr. Miscavige. And how do we know that? Because the Texas Supreme Court, not 2 weeks ago, handed down the Moncrief Oil versus OAO Gazprom marketing case, where they said a non-resident directing a tort at Texas from afar is insufficient to confer specific jurisdiction. So even if the plaintiff is correct that Mr. Miscavige sat behind his desk and said, go get Ms. Rathbun and surveil her, that, according to the Texas Supreme Court, would be insufficient to support jurisdiction in Texas. That is their best case of jurisdiction in Texas, and those facts are indisputably not true. Mr. Miscavige has submitted an affidavit from a personal affidavit attesting to the fact that he doesn't know these investigators and he had nothing to do with this supposed surveillance. So, Your Honor, when we get there, and I know we have some things we have to argue about as we proceed through the pending motions, and one of those things is going to be a motion that they'll have to get additional discovery, and we'll argue thoroughly about whether they're entitled to discovery under these facts. Our contention is that they're not entitled to discovery at all, that their pleading ties them to their jurisdictional facts, and that even if you accept everything they say in their pleading is true, there's still not sufficient jurisdiction to support personal jurisdiction on a constitutional basis. At that point, we'll get to the merits of the special appearance. With this background, hopefully the court will have a better appreciation for at least the arguments on both sides. And at the end of that, we will ask that Mr. Miscavige and the RTC be dismissed from the city for lack of jurisdiction. Thank you.
On how to go forward, in light of what I've already expressed with regard to my concern with the disqualification motion and related confidential and privileged information. And it's generally my understanding that perhaps what the idea here is, and it seems to be a good one, that we begin the temporary injunction hearing to a degree that if it's recessed, we can then move forward with a restraining order in place. I think that's the gist of what I heard in a lot of quick conversations after the conference. I might submit to the court, because I'm not exactly sure how to address some of the issues that Mr. Jeffrey raised with regard to what I believe to be confidential and privileged information in my opening. With regard to the injunction issues, there's been a lot of back and forth, and I think the majority of what we've talked about here this morning has been on special appearance jurisdiction issues. But there were some things addressed that I would need to address on the injunction. What I might submit to the court is that Ms. Rathbun has submitted an affidavit in support of the temporary restraining order in the original petition that is offered, I think, in support of the injunctive relief. We would agree to the entry of that affidavit as the testimony required at this particular point in order to ripen the hearing, if you will, so that we can move forward. I don't have to open any further, nor do we have to hear from Ms. Rathbun any potential confidential information, nor do we have to cross her on it somehow.
I appreciate the offer. I'm not sure that I can dictate that necessarily, or that everybody would have to agree. My point is that I did restrict Mr. Jeffries in the offer of any testimony to current matters. So we're not going back to 2004 or anything of the sort today at all. I'm not sure I can force him to agree to submitting that affidavit as his evidence.
Okay. I don't want to address the council per se, but
Your Honor,
ask him if that's
if I may help, there's two parts to this
I'm
case.
okay with it personally if that's the way we want to go.
There's two parts to this case. There's the Texas part that we've sued for, and then there's our burden, as you've already heard, they claim we can't do it, of showing who's responsible for all this stuff. That's the part they have concerns about. Who's responsible for it behind the scenes? Mrs. Rathbun's testimony will not touch on that, but it will have plenty of relevant evidence for the court to consider that she actually knows about that happened here in Texas. So we're not getting into that stuff. And no, we don't agree to use her affidavit. Generally speaking, affidavits are not competent evidence in an injunction hearing, and we don't agree.
But I understand, I mean, outside of agreement to the contrary.
right. And my proposal would be to submit the affidavit to ripen this hearing so that it can be recessed for the injunction of temporary restraining suspension. I wouldn't be asking that he would not, in addition to the affidavit submitted, be able to put Ms. Rathbun on for full direct examination when we reconvene. That would be part of my thought process.
Now, part of the delay between the last time we consulted in the chambers and me getting to the bench was just simply trying to look at the calendar, and the calendar is difficult. I'm probably going to be willing to receive a certain amount of testimony, but I do want it ultimately to be restricted to the issues at hand regarding the alleged injury, the harm, and why it's susceptible of injunctive relief. So, and all the other issues, to the extent it ultimately is dealt with, that will be at a later time.
Okay, thank you.
Yes.
Just very quickly again for the court reporter, I'm Les Strieber, Davis, Cedillo, and Mendoza. I represent CSI. And I'm going to try and kind of weave through what I've objected about, and then Mr. Jefferson covered some of the waterfront, also a general background about the church and things like that. So I'll try to be as brief as I can. When I was here, I guess it was a couple of weeks ago, one of the things and one of the difficulties I was having is I had just been retained. My firm had just been retained. And I've spent the past couple of weeks kind of trying to get my mind around an understanding of the Church of Scientology and its religion. And the reason I'm going here is because it's extremely important to have that understanding. And as I've gained that knowledge about the church, it's helped me understand the request for injunctive relief and the rights of both parties in this proceeding. I won't go into it any further. Mr. Jefferson did a good job, but the Church of Scientology is it's an established religion. Talk about recognition before the United States Internal Revenue Service and the law, but from a more practical standpoint, it's a very well established religion, and it's based upon the writings and teaching of L. Ron Hubbard. And I don't know if the court is familiar with Mr. Hubbard or his writing. Kind of the preeminent writing is the book called Dianetics, and it sets out a lot of his teachings and a lot of his thoughts that are the basis for the Scientology religion. It currently has churches in 150 different nations, and it both produces written literature, and it's like everybody else, it's available online. I think that year 19 million people has visited their website. So it's all over the world, it's all over the United States, it's all 50 states, and countries from Italy to Russia to everywhere else. I think Mr. Jeffrey said something about that this is not a religious dispute, but Judge, at its heart, it is. The plaintiff, Monique Rathbun, is the wife of Marty Rathbun. And as Mr. Jeffrey said, he was with the church for about 20 years, and he had a very high office within the church. There were circumstances in which he was asked to leave the church, and that was about 10 years ago. As Ms. Rathbun states in her affidavit, and this is very important for injunctive issues and directly with respect to the issue of whether or not there's been any harm. In her affidavit, paragraph number 4, she states, "We have been now living under this constant surveillance for 4 years." Jumping over some statute of limitations issues, which will be in the merits, with respect to the imminent harm, we will be asking the court to consider the admission in her affidavit that they've been aware of the surveillance for 4 years. You're also going to hear evidence that they contemplated, hired, and drafted lawsuits with respect to this activity over 2 years ago, and that was never filed. And so, on the issue of imminent harm, going directly to one of the issues related to injunctive relief, it's important. As Mr. Jeffrey said a few minutes ago, Mr. Rathbun left the church, and for 4 or 5 years, there's nothing. There was no controversy. There was no dispute between the parties. And as she states in her affidavit, she says in 2000, paragraph 3 of her affidavit, in 2009, my husband broke his silence about Scientology. He gave national media interviews. She says, "I've never been a Scientologist. I gave no interviews, nor did I speak publicly about these matters." But the point is, all of a sudden, after about 5 years of leaving the church, he started speaking out. And I'll skip the theatrics, but one of the ways that he spoke out is he started a blog. And I could ask somebody to put it up. I'm not. There's like 25 large 3-ring binders of all of Mr. Rathbun's writing on his blog, all of which are acidic, hate-filled criticisms of the Church of Scientology. It's daily. It's constant. Mr. Rathbun has been on Anderson, Cooper, you name a network, he's given an interview. You name a major national magazine, he's been given an interview. He's quoted throughout the television media in the United States, in Europe. He's quoted in all of the national magazines, local newspapers, San Antonio Express News, Florida newspapers, blogs. And Judge, there's blogs out there that are sole purpose is hatred towards the Church of Scientology. So I'm going to go back to tell you that this is a religious dispute. There are blogs against the Catholic Church. There are blogs against the Methodist Church. There's blogs in anything involving religion, because aside from politics and homeowners associations, there's always going to be somebody that is going to be defiant. There's going to be somebody with a personality that becomes obsessive and begins a crusade against whether it's the homeowners association, the Methodist Church of Bernie, where I'm from, or the Catholic Church in downtown San Antonio. And a really important issue in this case is the orthodoxy of religion. Methodists have an orthodoxy. The Catholic Church has an orthodoxy. Scientology, Church of Scientology, has an orthodoxy. And it is, there's scriptures. It's what is their religion. And Lamont can't go out and start a Catholic church that says Lamont Jefferson Catholic Church, put a great big sign that says Lamont Catholic Church. I can't do the same thing for a Methodist church. Not without a visit from somebody in the Catholic Church or the Methodist Church. An organized, established religion has the right to preserve its orthodoxy. It's the consistency. Their members, their congregation requires that consistency. And occasionally, all religions have a heretic that goes out and tries to change the orthodoxy, doesn't respect the orthodoxy. And there's nothing wrong with attempting to hold that orthodoxy, hold the scriptures to what they are intended to be and what the church has established them to be. This lawsuit, while it's in the name of Monique Rathbun, is a dispute between Marty Rathbun and the Church of Scientology. That's what this fight is, and it's over the orthodoxy of Scientology. Mr. Rathbun, through his blogs and through his own teaching, and by the way, his own business in which he's practicing some of the activities of Scientology. You're not going to hear Mr. Rathbun or Ms. Rathbun say, I disagree with Scientology. They're going to say, I disagree with the way CSI, my client, is holding its orthodoxy. That's the fight here. Now, I've coined my own little phrase called the Rathbun Cabal. There's a group out there in the United States that have teamed up with Mr. Rathbun. You're going to hear, I believe, testifying a man named Mike Render. You're obviously going to also hear from Monique Rathbun. The three of them and others are directly or indirectly involved in 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 different legal proceedings against the Church of Scientology. They're involved in litigation in Los Angeles, Southern District of Texas, Middle District of Florida, 6th Judicial District in Florida, San Patricio County, Bexar County, Moore, California, 15 different pieces of litigation. It's become an industry for him. And here we are in one more. And every one of them is a call to the media. Every one of them is played to the media. In this particular case, the next day after the lawsuit was filed, the media is calling. how does the media pick up on a lawsuit filed in, how does the media in St. Petersburg, Florida, pick up on a lawsuit filed in Comal County? How does,
Excuse me, I need to make an objection. Your Honor, I make very few objections, but they jumped all over me for arguing the case. Are they presenting evidence of any of this? This is just pure argument that won't even be in the record. I think he's going very far afield, and it's just plain false.
there's an issue of I'm sorry, Judge.
Oh, I mean, let's do try to stick, because we are here on a temporary injunction hearing for preserving the status quo if certain elements can be met. So, I mean, that's regardless of who shows up for open court. I understand what you're saying, but
I appreciate it.
I'd really just like to keep the opening statements directed to that, just as a argue to Mr. Jeffers as well.
Thank you. The second most important, maybe not even that order, element to a temporary injunction hearing is going to be their probability of prevailing on the causes of action that they have alleged. The essence of their causes of action is they do not like the surveillance that has occurred by the Church of Scientology on the Rathbun. It's important to understand that when there's a church with their orthodoxy that's being attacked, changed, modified, that they need to do something about it to preserve their own religion for the benefit of their membership and the benefit of the church. And so I'm bringing out what it is that Mr. and with the assistance of Ms. Rathbun has done is place themselves through the media, through daily, hourly blog activity, that place themselves in positions of public figures. And with respect to First Amendment rights, with respect to a company's or a church's ability to defend itself legally, 15 lawsuits, participation in lawsuits, consulting in different lawsuits, they have an ability to defend themselves and understand what it is that's being challenged in their orthodoxy and in their church. And so they're going to be asking the court to fashion some sort of equitable injunctive remedy that, let's just take this lawsuit, for example. They've been sued. They should have the ability to do what every defendant, what every company is entitled to do legally within the bounds of the law, within the bounds of the Constitution, to defend themselves, to understand both in terms of the orthodoxy of the church and the allegations that are going to be brought or are being brought against them. Another important fact, and I need to kind of walk the tightrope on this. Mr. Rathbun, while he was with the church, was in charge of, or I should say in charge of, worked with legal counsel and worked with other members of the Church of Scientology related to the trademarks of the church. The Catholic Church has trademarks. Methodist Church, Presbyterians, all religions have trademarks. And it's important for them to preserve those trademarks. We will submit, and evidence will show that Mr. Rathbun has continuously, since out of nowhere, he starts his fight with the church when he stops his silence, he starts violating those trademarks. Trademark litigation is difficult. There's always, or a patent infringement, any intellectual property, it's very difficult sometimes to understand how your trademark is being violated. You can walk up to somebody, you can have a letter, you can ask for a meeting, they deny that they're violating it, And so you need to do certain things to protect the trade. And so that's a context that needs to be understood with regard to the issue of probability of prevailing. It's our position, and the evidence will show in a temporary injunction hearing, that anything and everything that the Church of Scientology did to protect its trademark, to protect its orthodoxy, they did so within the law. They did not violate the law. They did not violate Ms. Rathbun's privacy. They did not violate the privacy of a public figure who has no legal expectation of privacy. And it's going to be our position at the temporary injunction hearing that because what we were doing was legal and within our constitutional right to protect our property and our members, that there's nothing that this court can do to enjoin any of the activities that they themselves are going to prove that we were doing. They're not going to prove that anything was illegal, that anything was improper, that anything was outside the bounds of the law, that an investigator can do, that anybody needs to do to protect, legally protect their property. I'll add one thing that I skipped over. In addition to his blog, you get on his blog. He has a video.
Your Honor, Mr. Rathbun is not a party to this case. His entire opening statement is about Mr. Rathbun. This is Monique Rathbun's case.
I understand. Totally mistaken.
On the blog that is with the assistance of Ms. Rathbun, Ms. Rathbun assists him in the administering of his blog. On his blog, there's videos that they post. There'll probably be videos from today posted. There's videos by Mr. Rathbun in which he calls out to all Scientologists, all members of the Church of Scientology, to bring him, in essence, to convert or steal property within the church. And at least on one occasion that we are aware of, a church member did in fact take computer hard drives in Los Angeles, California, and met Mr. and Mrs. Rathbun with that property. And it's important in addition to protecting the orthodoxy of the church, being able to defend itself in the variety of legal matters that they've embroiled themselves in outside of this lawsuit, to defend in this lawsuit, and to protect its confidential properties that he, on YouTube and on his blog, are advertising and soliciting people to steal and bring to him, and he'll protect. And so it's abundantly necessary that the church be allowed to defend itself, and any request for injunctive relief, those specific issues are going to need to be addressed and looked at with regard to any injunctive relief that would prevent them from being able to do so. Thank you, Judge.
Your Honor, if it's appropriate, I'm going to reserve my opening statement until defend this case. I'll add Mr. Sloat, certainly.
Yes, Your Honor, Monique Rathbun.
That testimony would be limited to the real issues at hand regarding preserving the status quo, the harm, injury, irreparability, etc., those necessary issues. If you want to call your first witness.
Do you want us to proceed now or take the break and then come back?
It is, it's 11:45.
I'm at the court's pleasure. I'm happy to call Ms. Rathbun and get started.
We might, go till about 12:30 or something. Yes, sir.
This is an issue I'd need to consult with co-counsel, but I just want to make sure if, I'm assuming that you aren't going to elicit, this isn't going to be the totality of the direct examination that you're going to elicit from your client.
No, in the back, we did mention that other issues would be reserved. If somebody else wanted to call for a different purpose, or even Mr. Jeffrey needed to recall that witness for other issues outside of, and we'll have to see where we get there, and a lot of, some of what your opening statements are directed to, we'll have to see how far we get, and that this is, again, a temporary injunction. I don't intend to try this lawsuit twice, and that's why every injunction has a trial date set, such that it doesn't become a permanent situation or injunction, so that we can get to the ultimate issues at trial. I don't want to try the case twice, so that's why we're really going to try to limit and maybe a little bit more vigilant.
And I was not articulate in what I was trying to understand. Will I have the ability, I just want to make sure, I think I do, but will I have the ability to reserve part or maybe even all of my cross-examination for when we reconvene?
Yes.
Thanks.
I'm not going to, we've got a lot of pretrial issues, but just looking again, fourth calendar, that's one reason why we're going forward a little bit, is just because time is going to be tight, and I don't want
I understand. Thank you.
to misuse or not use the time that we have set aside for certain issues, so.
And at this time, when testimony starts, is it my understanding with the cameras?
Yes, before we get there.
That's the only reason why I didn't say it, but why I was thinking you might want to take the break then, so they have time to get their stuff out. But
Well, we can do that, and probably if anybody needs to take a break, they can do that, and we'll just reconvene here shortly, but take probably about 30 minutes before we maybe take a, well, it might be more efficacious just to go ahead and take a lunch break and just come back at 1 o'clock, and then that way we can, everybody have ample time to get all the cameras